Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everybody in between. As you can see on the screen, I'm Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As always, I am an associate at Samfiru Tumarkin LLP, Canada's leading employee-side employment law firm. Housekeeping note, please send in your questions as soon as you can. I'd like to get through them all before the end of the broadcast. If you need to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, we've got a few questions trickling in. Please send them in now so I can get through to all of them before the end of the broadcast. Okay, what do we have here? Question from Desi. I was terminated for refusing to sign a new work contract. The employer was supposed to give me a contract to sign after my probation period, but that didn't happen, and I continued to work for another several months. Then they presented me with an annual contract because I didn't want to sign, they terminated me. What rights do I have in this situation? So I'll just start with first principles here. Generally, an employment contract is not there for the employee's benefit. A written employment contract is not there for the employee's benefit. It's there for the employer's benefit. What it does, or what the purpose of it generally is to use the employer's or mobilize the employer's superior bargaining power over the employee at the time of hire, contract formation, or at other points in the employee's employment, to get the employee to agree to a limitation of the employee's rights, either within the four corners of, we'll call it the main focus of the contract, or more likely with respect to what happens to the employee and the employee's rights upon termination. And so, and in many cases, that's really the primary focus of a contract. It's to limit the employee's rights upon termination, to limit how much money in severance the employee is going to get when that employee is terminated. So if your employer hasn't made you sign a contract, it's better that's good. It means that you have an entitlement to reasonable notice of your termination, which, if your termination happens immediately, would entitle you to common law severance, which is as much as 24 months, depending on your age, length of service, and position, if you've never signed an employment contract. So in this situation, so let's just say, I don't know, it's not clear from your question here, Desi, if when you were on your probation period, or initially when you were hired, if you were required to sign a contract and then you were supposed to get a new one, and then you were supposed to get one. My apologies. I'm having some connectivity issues. Just going to check, make sure I'm still live. Okay, yeah, I'm still live. Apologies for any lag anyone's experiencing. I apparently am having some internet issues. Okay, so it's not clear again to me, Desi, the specifics of your situation, but let's just say you had not signed a contract and then your employer asked you to sign a contract. It is within your rights to say no. For example, if you hadn't signed a contract before, it could be that you wanted the benefit of unfettered common law notice upon your termination. However, if you refuse to sign the contract, your employer has various options. Your employer can continue to have you work without a contract, which means that you preserve your entitlement to common law severance. It can fire you immediately, but then it owes you common law severance of your termination. Okay, or it can give you working notice, where it'll say, well, I'm going to impose this contract upon you in X amount of time, or I'm giving you working notice of your termination. So, for example, your employer could say, you're owed 10 months under the common law, and therefore I'm giving you 10 months of notice, and at the end of 10 months, your employment is ended. Okay? That is entirely, all those options are open to the employer. So you have to be prepared for that if you refuse to sign a contract. In your situation now, I think what you're asking is, well, what rights do you have in the situation? So your employer can terminate your employment without cause, which is what's happened to you at any time. Your only legal right in the event of your termination is severance, if they've terminated you effectively immediately, which it seems like that's what's happened. And so your rights are entirely monetary. You're entitled to severance. The question is, how much money are you entitled to? And that depends on if you signed a first contract, what it says, and if what it says, if it limits your termination entitlements, and if that limitation is enforceable, and then if it isn't, your age, length of service, and position. So it's a complicated question you've asked. It's not clear. I can't possibly diagnose all that from looking at one paragraph, but you may, depending on, well, I'll just say you should talk to an employment lawyer. It may be that you have a very short length of service, in which case it may be that you don't have very much severance coming to you. But nonetheless, you should find out. So you should talk to an employment lawyer based on the paragraph that you sent in. If you need to talk to us, please do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. 5900. Okay, let's move on to the next one. This is a question from Salty. My employer has continued to pay me after I quit my job. Do I have to notify them? Can they come after me for the error? What should I do? About you gave 4 weeks notice of your resignation, and they paid you for those 4 weeks, but now but after your resignation period is ended, they'll stop paying you? Or are you talking about how you gave your 2 weeks notice or 4 or whatever it is, you moved on, and they're still paying you way after the fact? Well, you're not, if it's that second one, which is what I think you're asking, you're not entitled to that money, and certainly they could come after you for it. Would they? It depends on the amount of money you're talking about, and how substantial the money is, and how litigious your employer or your former employer is. So I can't really answer that question. All I can say is, is that your money? No, it's not. If that's the situation, and probably. If your former employer were to come after you for that money, and you were aware that it was not your money, and you didn't notify them, I can't see you having any chance of success in court with respect to that money. However, would the employer come after you for that money? I don't know. It depends, and you may wish to notify them about the situation. But again, it could be that they're just paying you to the it depends on what's in your employment contract. It may be that you were required to give 4 weeks of notice, and you did, and they're still paying you for the end of that notice period. So I don't have enough information to answer that question. But do you have a right to money from your employer after you've quit because they made a payroll error? In the same way that when a bank accidentally transfers you too much money, you don't have a right to that. You don't have a right to free money from your former employer. Question from someone I can't identify. My cousin works at a dental clinic in Ontario, and for the past month or so, her employer said that she can work at another one of her offices to get more hours. She has been consistently working overtime, over 44 hours a week, but her employer has been paying her 2 different paychecks because the work is done at 2 different offices. Thus, she isn't getting overtime. Should she file a complaint? That's interesting. So I bet you what's happening is there's 2 different employers, incorporated companies, And so this particular dental clinic is saying, well, these are just different hours at different companies, and we're sister companies and we have a relationship. Is that legal? Is your sister, your cousin, entitled to overtime? Yeah, I mean, there's a strong argument that maybe, but the question is, does your cousin? I mean, it's 44 hours a week, so or a little over 44 hours a week. So is it worth it for your cousin to bring a complaint before the employment standards? I don't know what it's called in Ontario, employment standards branch, whatever the employment standards body is called, decision-making body is called in Ontario. Certainly, you could bring a complaint. You might be successful. You'd have to demonstrate that both companies were her common employer, but employers don't take too kindly to legal complaints being brought against them by existing employees. And so while she is protected against retaliation under, I mean, I assume she is. I don't know the Employment Standards Act of Ontario very well, but most of them protect employers or employees from retaliation. Nonetheless, I can't see your cousin working for this dental operation for that long if she does bring a complaint. So it may be her best resolution here, a small amount of money, 44. So it's time and a half on 4 hours, right? So it's 2 hours of pay. Maybe she can talk to the employer and figure out some sort of amicable resolution. That might be the best thing. But certainly, I think she could bring a complaint and potentially win it. It's structure of these two organizations, how it works, what are employment contracts. Nonetheless, it's certainly possible if they function as a common employer. But does she want to do that? Does she like that job? Is it, the fact that she can get, I know at a lot of dental clinics, it's hard to get up to 40 hours, so the fact that she can get 44 hours, is that worth it for her? These are considerations. I'll just say if she brings a complaint through Employment Standards Branch, I can't see her having a long runway eventually at a long career at that particular dental office, because I don't think the employer will take very kindly to it. So you've got to weigh all of that, or your cousin's got to weigh all of that, and then make her decision. It may be, like I said, her best bet here is to just have a friendly conversation with the employer about it and see if they'll reach some sort of compromise with her where they pay her some or all of the overtime. Sorry, my apologies. I can internet here. Morgan asks, during my 2-year LTD leave. Okay, so Morgan was on medical leave for 2 years, and received standard raises during those 2 years, even though it's not clear to me. I mean, you weren't getting paid by your company, so I don't know how that works. All my pay information is gone. I didn't get the raises. Can they just take away raises I received while I was on leave? I don't think you were actually getting those raises. So, I mean, the raises were. It may be that there was an automatic pay. Like, raises can either occur automatically at certain hours or threshold markers, or they can occur through deliberate exercise of discretion by the employer based on performance. If you're away for 2 years on a medical leave, it's hard for me to see how those raises actually did occur, and that what you were seeing was just simply a payroll error. I would talk to your employer about it and find out what that was about. But you were on leave for 2 years and you came back into the same job that you had at the same rate of pay. I don't see that there's any legal issue there or any legal cause of action. However, if you are interested in those, perhaps obtaining those pay raises, maybe you can negotiate that with your employer in an amicable way, and see if they'll let you keep some of those. So, especially with all the inflation that has happened over the last 2 years while you've been away, it may be that your employer has a sympathetic ear to your situation, especially because you saw and perhaps relied on those raises. Just trying to think if there's any expectation reliance on the raises. No, because you weren't getting paid. It would be. I think it would be different, again, depending on the size of the raises. But if you received the raises and then were paid that money over 2 years, and then the employer just said, "Oh, we're taking that money back," if the retraction of your income was substantial enough, you might be able to trigger a constructive dismissal. And I don't know that from which would terminate your employment, and then you could proceed to claim severance, as I talked about earlier, which again, in some situations can be quite lucrative. It can be as much as 24 months, depending upon your employment contract, your age, length of service, and position. But you certainly wouldn't want to do that unless, without a lawyer who could assess how much money you might be potentially entitled to. But that's not what happened here. You didn't actually, you were getting paid, I presume, through a third-party insurance company, and disability while you're on your medical leave, and then the employer just had payroll changes through the system, didn't announce to you by any other means that you were getting a raise, and then when you came back, saw that there was an error and corrected it, but you were never actually paid any of that increased money. So no, I don't think you have any legal claim to those raises. But again, it's a weird situation. You've just gone through a 2-year medical leave. I'm sure there's a tremendous amount of sympathy around that for you, and maybe you could leverage that sympathy to some degree in an amicable, friendly way with your employer to see if they'll let you keep some of those raises, especially given the cost of living and inflation and everything else that's happened while you've been away. So, if you want to try, again, you don't have a legal claim to those, or at least I don't see one. But if you wanted to try having a reasonable conversation with your employer, that may be productive. That's probably the only way you'll be able to see any possibility of keeping some or all of those raises, which again weren't actually raises. They just seem to be ADP. I don't know if glitch is the right word, but sort of an automatic addition that wasn't actually backed by anything else. Okay. Art asks, if you are let go from a seasonal position, how do you determine the length of your employment? Is the amount of years overall, or do you calculate only the months you worked? Well, this is a very good question, and one I could spend the whole broadcast talking about. So there are very few cases in Canada on seasonality, seasonal employment. Okay, but the core distinction that you need to be aware of and answer is, were you an indefinite seasonal employee, or were you a truly seasonal employee? So a truly seasonal employee would be someone who's hired to work the Christmas rush at a toy store, over 4 months, let's say, the holiday season, and then the job is over. Is that person entitled to any severance? No, they're there. They were there on a temporary basis. Okay. An indefinite seasonal employee is one who comes. We'll say a logger, someone who does logging, forestry in British Columbia, and works a 8-month season every year, and has done that for 3, 4, 5 years, 6 plus 10, whatever it is, and everyone understands that logger is coming back, and the logger doesn't have to apply for the job again, doesn't have to sign a new contract. It's not an individual discrete season. The employee is working for that employer indefinitely. It's just that you can only conduct forestry operations for 8 to 10 months of the year because of the weather during the winter. And in a situation like that, then they are an indefinite employee, just like every other employee, indefinite employee. It's just they only work a defined period of time. And so in situations like that, where it's an indefinite seasonal employee, and that's the real question, you're still limited by the nature of the season. So if you're terminated, and there is some argument in the law on this question. This is the way I understand it, but I've certainly had disagreements with other lawyers about it. If you, let's just say your season goes from May to October. If you're terminated in October, your fallow season, where you wouldn't be working, your notice period runs from October, which means if you're only entitled to 5 months of severance, you're going to get 0. Whereas if you're terminated in May at the beginning of the season, you're going to get May, June, July, August, September, potentially, right? So it just depends where you're going to be terminated in the nature of your season, because you're not entitled to credit for the part of the season that you wouldn't have been working anyway, if that makes sense. Seasonality, very complicated. Art, I don't know if you're in BC. I do have quite a bit of experience on seasonality questions. So if you're in BC, well, maybe the moderator can put my contact up on the screen. Please feel free to contact me, and I'll see if I can assist you. There you go. That's my contact's in the top left corner there. If not, certainly, I do recommend you talk to an employment lawyer right away, and you can get a hold of us if you want at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But again, Art, seasonality, seasonal employment, challenging, but certainly there is a path, depending on your specific facts, to potentially, some good severance there. So certainly you need to talk to an employment lawyer. But those are the two big questions: were you an indefinite seasonal employee or a discrete seasonal employee? If you're discrete, you don't get anything. If you're indefinite, depends on where your season falls, your employment contract, some other things. Okay. If you were let, as a new person, I'll just call them R. If you were let go from a contract position, annually renewed, are you owed anything on termination? Okay. This is how much time do we have? How many questions? Okay, we've got a bunch more questions. Okay, there are two components to your question here, whether you're a contractor or an employee. So lots of places retain the services of what I'll call employees, but call them contractors. But they're not actually and they pay them like contractors. They don't deduct CPP and EI. They don't withhold income tax, and et cetera. But they're not actually contractors. They're employees. And so the core of the test is whether or not the employee is working for the company or the employee is working for himself or herself. And so if you can pass that test as an employee, you're entitled to common law severance. Same thing if you're a dependent contractor, but we don't have time to get into that. There's 3 categories: employee, dependent contractor, independent contractor. And so, and there's different implications of each one. And I certainly don't have time to get into that. But let's just say you're actually, even though you're paid as a contractor, you're really an employee, and therefore you're entitled to severance. Your second question is, you signed a contract that was renewed annually. Are you owed anything on termination? So this bleeds into, I think, a different concept, which is you signed a series of fixed term contracts, which are, you're employed for, R is employed for 1 year, at which point his employment ends, or it's renewed for another year. And so the question is, what happens if that's renewed a few times? Well, the law says you become an indefinite employee upon, we'll say, 3 of those renewals. And so you're no longer, it doesn't even matter if you have more year by year. You can't, what if you went 25 years with 1 year renewals? You're not a 1 year fixed term employee at that point. You're an indefinite employee that just has this language in the contract. The interesting question is whether or not the terms of the contract still apply to you. And there's some debate on that as to whether or not, well, once you become an indefinite employee, the contract no longer applies. especially if you're signing a renewal every year, but you're not getting fresh consideration for it. In order for a new contract to bind your after you've started employment, in order for it to bind your entitlements and your rights, you have to be provided fresh value for signing it. However, there is some possibility that, yes, the original contract still does bind you if it's got a termination clause. And so I'm of the view that it doesn't, that the relationship substantially changes once you become an indefinite employee after several renewals of the contract, but it would depend on the situation. And I certainly can't answer those questions based on a 3-line question. So I very much encourage you to contact a lawyer. And again, you can contact us at the usual information. There you go. See it on the screen. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But those are really complicated questions, and I encourage you to talk to an employment lawyer as soon as you can. Okay, I'm going to try to race through these questions here. Kay asks, how reliable is your severance pay calculator on your work site? I don't really understand the question. It takes. In fact, I'm gonna decline to answer the question. It's not other than to say a calculator of severance based on the Bardall factors that inform the assessment of severance, of common law severance, your age, length of service, position, availability of similar employment. That doesn't take into account, do you have a right to reasonable notice under your contract, and it's not 100% substitute for individual judgment. So it's a tool to assist you to understand what you're entitled to potentially upon termination. But certainly after you've reviewed it, I recommend that you speak to an employment lawyer. If you look at the severance pay calculator and it shows an amount that would be of interest to you, we'll say, certainly feel free to contact us. I'll put the contact information on the screen at the end. But it's just to reiterate, it's a severance calculator. It doesn't take into account all the other potential factors, facts, and risks that exist on any potential severance case. So I hope that answered your question, but you should always talk to an employment lawyer. Next question by JW. Is there a form I can give to my employer for a 90-day probation period where I'm entitled to a layoff if I feel that employer is not good for me? I don't understand the question. You want to lay yourself off? Where I'm entitled to a layoff that I feel that employer is not good for me. You're not entitled to place yourself on layoff. You're effectively quitting if you do that. I can't really answer the question more than that. Kay is back. I believe my situation is pretty simple and straightforward. Can I count on the estimates provided in the severance calculator? The severance calculator is not a legal opinion. It's an estimate of reasonable notice if all other, based on, we'll say, the factors that inform the calculation of common law severance, but it doesn't take into account all the facts of your case. You have to talk to a lawyer in order to get a proper assessment of the value of your case. JW is back. I'm wondering about this because this is the person who wants to lay him or herself off, because I deal with a lot of jealousy and discrimination in the workplace and often find the workplace is toxic to be in sometimes. Again, you have no right to place yourself on layoff. What you'd effectively be doing is quitting. But if you don't like your workplace and you just started, it may be that you should vote for your feet and consider working somewhere else. I think that's pretty much it. Okay, we've got one more question. Again, P.S. I can't really identify this person. If you were terminated due to a disability and they're not wanting to follow the ADA, I don't know what that is, what does that case usually look like for an employee of 3 years? I don't understand the question at all. I'll just say there's no jurisdiction in Canada where the employer can terminate without violating human rights. Legislation can terminate you because of a disability. Now it might be different if you've been away on medical leave because of that disability for over 2 years with no possibility of returning. Then your employment might be legally frustrated and dissolved. But you can't be terminated due to a disability, and you will have, at minimum, a human rights complaint through the applicable human rights body in your jurisdiction. Okay, lots of good questions today. Thank you all for all of them. We did manage to get through all of them. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Join us next week on Monday at 1:30 p.m., April 28th, with Chris Justice. He'll answer all your questions about all things employment law. Other than that, I hope all of you have a wonderful and safe weekend. I'll be back in 2 weeks at the same time, 10:30 a.m. Pacific time. Thank you, everyone, for attending. And